Good afternoon. I'm Tracy Gordon, Vice President of Tax Policy at the Urban Institute and co-director and acting Robert C. Posen Director of the Urban-Brookings Tax Policy Center. It's my pleasure to welcome you to how the Supreme Court case Moore versus United States could alter the tax landscape. Before we get started, a few housekeeping notes. We are broadcasting and recording this event. The recording and related materials will be shared after the event and posted online. The speaker biographies will be posted there as well. We've enabled live captions, and they can be turned on by clicking the live transcript button on the bottom right corner of your media player. All participants are muted, but you can submit your questions or comments in the Q&A box at any time. If you would like to join the conversation on social media, please use the hashtag #LiveAtUrban. And lastly, we are always looking for ways to broaden the conversation on tax and fiscal policy to include the latest issues and to identify solutions. We are especially interested in hearing from a variety of perspectives, voices, and backgrounds and experiences. After today's event, we'll be emailing a link to a survey. If there are topics that you'd like to see covered or future events that you'd like to see us think about, please don't hesitate to share your feedback in that survey or by emailing us directly at info@taxpolicycenter.org. Now on to our program. The 2017 Tax Cuts and Jobs Act lowered the corporate tax rate from 35% to 21% and moved the US to a more territorial system that for the most part taxes income where it's earned. As part of the transition to that new system, the TCJA also subjected about $3 trillion in undistributed corporate earnings that had accumulated overseas to a one-time mandatory repatriation tax. In Moore versus United States, petitioners are challenging the constitutionality of that tax, arguing that the 16th Amendment does not authorize Congress to tax unrealized sums. But the case has much broader implications, as we'll discuss throughout the day, for individual, business, and corporate taxation, and international taxation. As part of that discussion, we're excited to share some preliminary TPC estimates that give an idea of what might be at stake for federal revenues, economic efficiency, and equity. Before we dig into those questions with our terrific array of speakers, I'll turn things over to my NYU Tax Law Center, Chai-Ching Wang. Many thanks for all of you to all of you for joining us.
Thanks so much, Tracy, and I'm so thrilled to be partnering with the great team at the Tax Policy Center to bring you this event. As Tracy just noted, this program really asks us to think about the implications of the Moore case, and I hope that you'll come away thinking that quite a bit could be at stake. But it's important to note that that's a point of debate, and in fact, it's a really central question in the case. The petitioners claim that what's at stake is an unprecedented tax in the 2017 tax law and as yet unenacted reforms like broad mark-to-market or wealth taxes. And that could be enough, but as the panels will explore, it could also be far more than that when it comes to the implications for the tax landscape. The basic logic that the Moores asked the Supreme Court to adopt could raise questions about many long-standing provisions of the code, and the potential implications of the case flow from the challenge of distinguishing those provisions from the one that the Moores are challenging as unconstitutional. So before turning to this great exploration, as Tracy flagged, of the economic and tax administration implications of these debates, our first panel is really going to set us up by looking at the origins of the debates, by exploring the history and context of the 16th Amendment. So it's my great pleasure now to introduce Vanessa Williamson, who is a Senior Fellow at the Urban-Brookings Tax Policy Center and a Senior Fellow in the Governance Center at the Brookings Institution, and who will be our wonderful moderator for that first panel. Over to you, Vanessa.
Thank you so much, Chai-Ching. I am so excited to be here today and to get to introduce a really remarkable panel. First, I want to introduce you to Ajay Malhotra, who is a professor of law and history at Northwestern University and a research professor at the American Bar Foundation. He is also the author of what I have to say is, in my opinion, the best book on the origins of the income tax, Making the Modern American Fiscal State, Law, Politics, and the Rise of Progressive Taxation. I can't recommend it to you highly enough, honestly. And he is joined by Jake Brooks, a law professor at Fordham University, whose research areas include tax law, public finance, and the constitutional law of taxation. He is also the author of a really fascinating and useful new article with David Gamage in the Tax Law Review called Taxation and the Constitution Revisited. And again, I'm just so excited to have such a star-studded panel today to talk about the sort of historical issues leading up to this case. But first, just to sort of level set a little bit, Jake, could you give us all just a little bit of a summary of the case itself and a little bit about the stakes?
Yeah, so as Tracy mentioned, the this mandatory repatriation tax that was introduced by the TCJA taxed unrepatriated retained earnings of controlled foreign corporations. And leaving aside some of the international tax details, what the Moors here, the Moors are individual minority shareholders of a private Indian corporation. They sued saying that these undistributed corporate earnings cannot be income under the 16th Amendment. And they base that argument primarily on sort of an argument about the meaning of income and also in particular this, the 1920 case of Eisner versus McComber. So but the district court and the Ninth Circuit both held for the government, saying that this was income and could be taxed constitutionally, but the taxpayers petitioned for cert to the Supreme Court, and as we know, that was granted. And so the question presented here in the case, as phrased, in the petition, is that whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. So it's a question about whether essentially undistributed corporate earnings can be considered income for purposes of the 16th Amendment.
So I think that there's a long history here that we want to get into across the panel, but I want to this already the question of apportionment raises a lot of historical questions. Could you give us a quick overview of sort of the history of federal income taxation generally and what this apportionment clause has been, how that has been sort of intervening in that history?
Yeah, so since the case really is about the 16th Amendment, ultimately, it's good to have a little bit of background. Now, the Moore petitioners, and also to some degree the McComber opinion from 1920, that they are relying on, argue that the phrase from whatever source derived. So the 16th Amendment says Congress can impose taxes on incomes from whatever source derived without apportionment. And their argument is that that phrase sort of embeds a realization requirement, that there's a requirement that income must be separated from property, converted into money in order for it to be derived. But the history shows that the phrase actually really is something completely different. So you have to go back to the Civil War. So the first federal income taxes were during the Civil War, and those were challenged at the court. And the court held in a case called Springer versus United States in 1881 that income taxes were excise taxes, not a direct tax that requires apportionment. Now, I want to skip over, I think, exactly what apportionment requires. That's not really at issue here. The key really is just whether a tax is a direct tax or an excise, and they held that an income tax was an excise. Now, and thus did not require apportionment, and Congress could go ahead and do it. So then in 1894, there was another income tax, but that was the one that was struck down in 1895 in the famous Pollock case. And it's a confusing opinion. I don't want to get too much into the weeds, but it is important to note that the Pollock case did not say that income taxes were direct taxes. It was understood at the time that direct taxes more or less were taxes on property. And so the focus of the Pollock case was just whether a tax on the income from property should also be considered a direct tax. And they ultimately said that it would be based on that kind of looking through the tax to the source of the income. But they still said that income taxes generally were still excises and not direct taxes. And so in 1909, then, when Congress wants to, overrule Pollock and pass the 16th Amendment, they drafted the amendment to say that taxes on incomes from whatever source derived need not be apportioned. And so they're saying, don't look at that source anymore. It doesn't matter that the income is coming from property. You can still treat an income tax as an excise, not as a direct tax. And that is something that later cases of the Supreme Court make very explicit. Now, we can get into sort of, the idea is that the amendment was reinstating income taxation as it was understood prior to Pollock by overruling the portion of Pollock that said income taxes on property were suspect. Now we can get into what the sort of that prior understanding of income taxation was, but for now the key is that this phrase "from whatever source derived" was doing the work of repealing Pollock, not of embedding a new realization requirement.
That's a really helpful background. I actually am going to force us to take it back even further in the history. Ajay, I want to bring you in for this. I think it would be a reasonable question for just an average American who's very used to paying the income tax, or even people who do tax policy, to ask, why is it we had to have a 16th Amendment in the first place? That is to say, what about the Constitution? Why is there this direct tax clause to begin with, and why was the Pollock decision such a surprise to people after after we had already clearly had an income tax once? So I'll go back a little further and get us right back to the founders, if you don't mind.
Yes, of course. Yeah, no, I think it's very important to keep in mind the broader sort of historical context and the sequence of events, the chronology that leads up to all of this. That's really important. I completely agree with the way Jake has described how the 16th Amendment has come about. But if we go back to the founding era, I think, as most people know, the direct clause and the Constitution itself was really a reaction, a response to the weakness of the Articles of Confederation, particularly the rather weak taxing powers that really undermined the entire federal government in the Articles. And so in that sense, the constitutional provisions, that all the tax provisions, frankly, are meant to empower a new nation state. There are limiting principles, of course, but the overwhelming context and sequence of events suggests it's much more about empowering the federal government. I think we also see this from the broader geopolitical context in which the framers were operating. At the time, they were well aware of the fiscal powers of the other great European nations, and Alexander Hamilton in particular wanted to make sure the new republic had those kinds of fiscal powers, the taxing powers, to be a credit-worthy nation. In addition, colonial taxation, even before the Constitution, direct taxes were on property, as Jake has mentioned, and so there was already this sense that the subnational governments were going to deal with property taxes. And so in that sense, the direct tax clause, when we look at the broader context and the sequence of events, really is more about a division of labor between different levels of government than it is a hard restriction on the overall power to tax. Now, of course, the direct tax clause, like much of the Constitution, was a compromise, right? So there are limiting principles in there, of course. But this, again, the sequence of events and the broader context indicate that the overall goal was to give this robust taxing power. To the degree that one cares or believes that we can actually capture an original meaning of the direct tax clause from the Constitution, I think that's hard. There's not a lot of direct evidence from the time about the definition of direct, as Jake has already alluded to. But the general sense was that the direct taxes were limited to taxes on land and poll taxes, head taxes. Capitation is the language used in the Constitution. And we know that from some of the earlier cases. So Springer, as Jake mentioned, is very important. But even earlier than that, the Hilton case in 1796, this is within a decade of the adoption of the Constitution, the court deems a tax on carriages to not be a direct tax. And then, of course, Springer and others. And so in this sense, I completely agree with Jake that Pollock was in many ways a surprise and a shock to most legal and economic experts at the time. I think they were surprised that the court was willing to hear the case. This might sound familiar. I think many of us were surprised that Moore was going to make it to Supreme Court. And then I think there was just downright shock and disappointment and outrage at the ultimate decision in Pollock. And so in that sense, if we put all this into a longer array of antebellum taxation, we see that really Pollock, as Jake has already suggested, was a historical outlier. It kind of set us on a different path in this path-dependent process, sort of overturning a century of jurisprudence. And in that sense, the 16th Amendment was a backlash, and it was intended to put us back on the original path.
So Ajay, you raised this question of sort of what people meant at the time, and I want to follow that up. Saying, since we're sort of restarting from the 16th Amendment, right? Jake, can you talk to me a little bit about the 16th Amendment is very short, it's very brief and to the point. What was meant by income in that amendment?
Yeah, great. So yeah, as Ajay said, it was this kind of, interregnum period basically, that between Pollock and the 16th Amendment, where things got thrown off, and in passing the 16th Amendment, Congress passing it and then states in ratifying it, the very clear intent, if you look at the congressional record and other evidence, was to essentially, as Ajay was saying, like essentially overrule that part of Pollock and bring us back to what the 100 years of jurisprudence up to 1895 had understood to be the role of income taxes and just taxes in general. And so then we need to ask, well, okay, what was that understanding of income taxes? What did they, if they believed that they were essentially resetting back to that period, to that understanding, what is encompassed in that? And in more, the petitioners are arguing that that we should understand income, particularly as used in the 16th Amendment, to embed this very sort of strong realization requirement that property has to be converted into money, or that the gain has to be separated from the capital in some way for it to be income. But this is based on at best kind of a disputed just reading of a sort of linguistic analysis, if you will, when in fact we have evidence of what was intended. So some evidence of that includes the fact that the Civil War income taxes, for example, explicitly taxed corporate shareholders on undistributed corporate earnings, exactly the question at issue in the Moore case. There was essentially, it was essentially pass-through taxation, much like partnerships today. And by the way, the taxes also included stock dividends in income, contrary to the McComber decision. Income taxes that were debated as alternatives to the 16th Amendment in 1909 also would have done something similar. The 1913 income tax also had pass-through taxation of corporations if the corporations had large retained earnings. So it's essentially a discretionary choice by Congress to defer the taxation of some earnings, unless that grant of deferral was being abused. So, again, if that was the contemporaneous understanding of what income taxes could reach at the time. And also, and this is, I think, really interesting, it turns out that the 1909 corporation excise tax, which was a tax on corporate income passed by the same Congress that passed the 16th Amendment, incorporated mark-to-market taxation of gains. So multiple Treasury decisions said that if a corporation increased the value of its corporate assets on their books, that increase would be included in the corporation's gross income, or loss if they were booking a decrease in value. And by the way, there also were similar regs issued for the first post-amendment income tax in 1913. I've also seen some evidence that financial accounting followed the same method in some circumstances. So in other words, with respect to this corporate income tax, the income tax that was in effect at the time of the 16th Amendment ratification incorporated mark-to-market taxation of unrealized gains. So this should all be understood to be authorized by the 16th Amendment. The court made clear that the 16th Amendment did not add to or take away any power that Congress had prior to Pollock. It was meant to just kind of level set back to what had been understood, wind back the clock to that period. And so that should include all these examples of income taxes and therefore income itself, as I mentioned.
So I have to say that I find this really quite convincing, and so but I was thinking to myself that I would have found the Pollock case an open and shut case if you had asked me in 1894, right? And then I would have been quite surprised by the outcome. So I think that when we're thinking about Supreme Court decisions that come as a bit of a surprise, and as Ajay suggested, there was quite a backlash to Pollock, right? And that wasn't just a backlash, in the courtroom or a backlash even in the legislatures, right? There was sort of a popular, a popular movement that responded to this quite surprising Supreme Court decision. I wonder if you could sort of tell us a little bit, Ajay, about that larger movement that was operating, outside of the courtroom.
Yeah, sure. It's important to put all this into a broader context. And of course, the 1894 income tax and the Pollock decision, these are all at the height of the progressive era. This is the time when social, political, and economic conditions are really agitating for all kinds of reforms, not just the progressive income tax. It's really about addressing the growing economic inequality of the first Gilded Age. We often refer to today as the new Gilded Age, but if we go back to that first Gilded Age and the sort of broad social dislocations wrought by industrial capitalism, there was this broad movement for the state to do more. And so in that sense, the Pollock decision was a sort of an objection, an impediment to those movements. If you look at Stephen Fields's concurrence in Pollock, it's rather alarming about it. He's worried about class warfare that the income tax and progressive taxation will bring. And certainly the push for an income tax was much earlier. I mean, the seeds for it are there among the experts. Certainly the professional lawyers and economists and accountants are making claims for about a new system of direct and progressive taxation based on the concept of ability to pay, which is, I think, central to our understanding today of an income tax. And then if you look at just other evidence of a kind of bottom-up social movements. Many of the independent political parties of the late 19th century, from everywhere from the Greenback Party to the Anti-Monopoly Party, the People's Party, they've all endorsed an income tax well before the 1894 income tax. So it's really this push from below and then from above among the experts. And then, of course, Pollock, in a sense, becomes a triggering event that then leads the Democratic Party to endorse income tax, the first major party to do so in 1896, the year after Pollock. And so this is a long-standing move that really kind of culminates with Pollock in the 16th Amendment. But the road is much longer and goes back quite a ways. And as you suggested, Vanessa, amending the Constitution was no easy task. All right, 3/4 of the states, which at the time was 36 states. That's why it takes almost 4 years from the time it's introduced to get ratified. But again, what's important is to see the broader picture, pulling the lens back and seeing how this was really a culmination of a much larger movement. What people were trying to do was really, as experts at the time put it, round out the existing tax system in the direction of greater distributive justice, to complement or to supplement, frankly, the existing 19th century system of regressive consumption taxes in the form of a tariff. The answer was a progressive income tax. And that's one reason why some of the strongest opponents to the amendment came from conservatives who benefited from the protective tariff, right? So these kind of underlying political pressures were there from the start.
Yeah, I think one of the things that really surprised me when I first started looking into this history was just how popular the income tax was across the United States. So the income tax wins in the Western states where there are not that very many rich people, and it wins in the South where the tariff is, of course, much despised, but it wins in places like New York State. I mean, not that it was easy, but there had to be this immense mobilization. If you try and imagine doing something equivalent today, passing an amendment in 3/4 of the states, what it would take to achieve that is really extraordinary. All right, so now here we are. We've got our 16th Amendment in place. Yeah, that's it, right? That we never argued again. That was the last time we complained about income taxation, and all has been easy. No, in fact, it's already come up a couple times. Eisner v. McComber. Jake, I wonder if you could jump in here and tell us a little bit about this case, which is probably, I suppose, is sort of the next big fight after the 16th Amendment is put in place.
Yeah, based on what I was describing and Ajay was describing, you'd think that everybody was on the same page about what the 16th Amendment was doing, and even the court, in some initial opinions right after the 16th Amendment, Bruce-Haber, especially Stanton versus Baltic Mining, they make pretty clear that the idea was really just to we wanted to go back to how it was. The 16th Amendment is not changing any understanding of income taxation or granting any new power or taking away any power that didn't already exist. We're really just trying to sort of get back to what things were before Pollock for all the reasons that Ajay described. So, but then you get to Eisner versus McComber, right, which is this famous decision that we've all studied. That issue, the specific issue in the case was stock dividends, the inclusion of a stock dividend in shareholder income. without getting too much into kind of the finance and accounting elements there, but where the court ends up really landing in that case is to say, well, we don't think a stock dividend is in and of itself income, and so really what we're asking is, well, can Congress tax, again, shareholders on undistributed earnings? Because with a stock dividend, there's no actual cash earnings that leave the corporation. Can they nonetheless be included in a shareholder's income? And the court says no, and in part because we think that a tax on undistributed earnings is a tax on the value of the corporation itself. It's a tax on property. It's therefore a direct tax that would require apportionment. And as I said earlier, they kind of hinge this analysis on this meaning, this phrase from whatever source derived, and particularly that word derived, and sort of reading the word derived as implying this requirement of a version of realization that focuses on separating the income from the capital. And as I said, I think that's the wrong way to read that phrase and what it was doing. It wasn't changing any understanding of income or of the sort of what Congress was trying to tax. It was there with the purpose of overruling that portion of Pollock. But nonetheless, so in Moore, there's sort of two main arguments. Well, the three main arguments, as we've discussed. One is this original meaning of income in the 16th Amendment, which we've already addressed. Then there's the argument of saying, well, regardless of that, you got to follow your precedents, and McComber is one of those precedents. The third argument is essentially, as Tracy mentioned at the top, that this is really about wealth taxation, but that's we can get to that. And so just briefly on the McComber case, I mean, you already mentioned why I think they misunderstood what this word derived meant. But there's a couple of other errors in the decision that I think are important. And I'm not going into in full detail here, but I just think we should understand that it's a controversial and ultimately pretty poorly reasoned case. I mean, one thing is that they do ignore and dismiss a lot of the prior history of income taxation that I mentioned, sometimes in a pretty cavalier way. They ignore sort of as I said, how to read derive. And the other thing they do is that they do, and it's not directly related to the issue at Moore, except maybe that wealth taxation question, that they don't do any real work in the case, the justices, the majority, on the question of whether a tax on stock dividends could be some other kind of excise rather than an income tax. So the thing that really, to just back up, we talked a little bit about the direct tax clauses, the important limitation for constitutional purposes is if the tax is a direct tax, it has to be a portion among the states based on population. Without discussing how you do that, we just sort of take as granted that that's very hard to do, and that's why you don't want to be a direct tax. In McComber, they said a tax on stock dividends is a tax on the undistributed corporate earnings, which is a tax on the value of the corporation itself, and it's therefore a direct tax. But they skipped a step there. They don't ever ask themselves whether, even if it's not income, could it be some other kind of excise tax? And importantly, could also be a question in the Moore case itself. It's a question that the dissenters in the Ninth Circuit also did not ask themselves. And it's a question that, it's unclear whether the court is going to be, asked to address it in this case. But it's a similar feature in the sense that it's a flaw in the McComber case, and it could be it's a under-discussed element of the Moore case is there some other way you could do an unapportioned tax other than as an income tax? Could it be some other kind of excise?
So I hear you calling McComber poorly reasoned and it was cavalier. How, Ajay, this is for you. I'd like to know, tell me a little bit about how the courts have dealt with this very awkward precedent in the intervening period before Moore.
Yeah, there's been a lot written about McComber, and I've learned a lot from the work of Marjorie Kornhauser and others on this. And so I completely agree with Jake on the way most of us today interpret McComber. I don't think there's a case that directly overrules McComber, but certainly the subsequent jurisprudence, the decisions after McComber really followed more of Justice Holmes's dissent than it did the majority opinion, where Holmes essentially agrees with the administrative aspect of not taxing stop payment, but he really makes in this very characteristically Holmesian short opinion where he essentially just states that the main objective of the amendment was to get rid of what he calls nice questions as to what might be direct taxes, and that most ordinary people who voted for the 16th Amendment, to get back to your earlier question, Vanessa, right, that they were putting aside these kind of technical issues before the court, and this isn't where the court should be going post 16th Amendment. But then I think you do see subsequent courts chipping away at the notion that realization is somehow a constitutional requirement. That's really what's at issue here. And more, as I think the Ninth Circuit flagged and as Jake just mentioned. And so we start seeing very early, and at least in dicta, as early as 1929 in Taft v. Bowers, that the amendment does not attempt to define income or to designate how taxes may be laid. So this right away, and then certainly in the post-New Deal court, of course, the composition of the court matters, as we know, is much more open to a positive state and allowing Congress to define income. So you see a whole slew of cases in the 40s and 50s, the Horst, the bond stripping case in 1940, the leasehold improvement case in Brunn, Glenshaw Glass, and those of us who teach this material cite to these cases and discuss them. And of course, cottage savings in 1991 all suggest that realization is an administrative convenience, not a constitutional requirement. And so in that sense, I think the Ninth Circuit majority got it just right when it concluded that realization of income does not determine the tax's constitutionality. And again, if we look at the broad context, the broad sweep of Supreme Court doctrine on the realization requirement, I think it's fair to say that it's really been modified or frankly transformed in about three short decades. Not a lot of time for constitutional change, from a constitutional requirement in McComber to really mere administrative convenience in cottage savings, right? And I think this has really given Congress and Treasury much more latitude, and I think subsequent panels will talk about all the implications, not just the international context in which the Moore case is entrenched in some Part F income, but my gosh, the financial instruments that exist today, just zero coupon bonds, OID issues. I mean, there's a tremendous amount at stake in getting the history right, frankly, and I really hope the court will.
I wanna stick with you actually for a minute and talk about this idea of getting the history right. I think Jake, you said something about that at certain points the court seemed more interested in sort of linguistic analysis, which sort of seemed to me sort of like maybe a degree in literary criticism rather than one in law was really what was at issue here.
If only.
There's so much debate. What does it mean to be direct? What does it mean to be derived? And so, Ajay, I'd love for you to put on your historian hat for us for a moment and talk to me a little bit about this theme that is important in this case, but I think is important for many Supreme Court cases across a wide array of issues. This idea of originalism, getting at what our founding fathers meant by their, by the wording that they chose for the Constitution. So can you talk to me a little bit about how this idea of originalism is seen by people whose job it is to understand and interpret history?
Yeah, that's a great question, Vanessa. So I think we all know that originalism has become increasingly popular as a mode of constitutional analysis, particularly among several members of the current court. But I think for most historians, we really wouldn't consider it a form of historical analysis or historical interpretation for several reasons. Now, as I've mentioned several times, from history needs a greater importance to broader context and sequence and chronology rather than the text of the document itself. Historians are much more interested in that broader context that give rise to this particular text to better understand not just the text, but what is the social and cultural mindset that gave rise to it. And then when one does focus on context, on the empirical sort of details of a particular time period, then you really see the complexity of the past, which really puts into doubt that we can come up with one kind of metaphysical, essential definition of a term like direct tax. There are multiple meanings, right? People would, to this day, it's hard to say that about recent events and recent legislation. And then third, and perhaps most importantly, I think historians are really much more interested in knowing the past on its own terms. Originalism doesn't really adhere to that. It's much more of a presentist form of constitutional interpretation that frankly is much more of a political project than it is an analytical one. Lots of scholars have written about how originalism fits with this larger post-1965 kind of move to the rise of the conservative legal movement. And so I don't think most historians think of originalism as a form of historical analysis. But because of cases like this, getting the history right matters. And so I think doing the history properly also matters.
No, I did not know we were going to get from literary criticism all the way to metaphysics today, but that's great. I'm for it. All right, so I want to, in our last, this is going to be, I think, probably the last question we have time for, but Jake, I want to bring it to you to sort of get at the elephant in the room a little bit, right? Because it has come up in passing, I think, in the introductory remarks, and you sort of gestured at it yourself. The wealth tax, right? Now, this is an idea that sort of, I think, re-entered the popular consciousness, in the last 10 years. And, various, of course, wealth tax proposals have come forward. And of course, this, opened up a lot of opportunities for, questions about, this direct tax clause and what it all means. First of all, how is the wealth tax implicated in the Moore case, right? And then more generally, does it matter for the case, and does the case matter for the wealth tax? I guess I was asked it both ways.
Yeah, no, I mean that is really the elephant in the room here, and it's not a hidden thing. I mean, it's right in the briefs, and in some sense the petitioners and especially a lot of their amici are saying you need to draw a sharp line here in order to prevent wealth taxation, because that was what's implicated by this direct tax clause. That if you want to credit or sort of ensure the Constitution's requirement of apportioning direct taxes has some force, they say you need to you need to make sure that there isn't that Congress couldn't essentially do kind of a maybe like backdoor wealth taxation through income taxation. And so there's kind of two things at issue there. One is just what might this case have anything to say about wealth taxation in the sense of some kind of a property or property-like tax, a tax on the gross value of property. And to that, I'd say very little. And then there's the question of, well, are there other ways that Congress could do something like a wealth tax that might be closer to this? And so I'm thinking here of other forms of like mark-to-market taxation, or something like the billionaire's minimum income tax proposal that is a form of mark-to-market for very high net worth households. And seeing that as sort of like a wealth tax, even though structured as an income tax, as a mark-to-market income tax. And so I guess there's two ways in which, or a couple, on both those questions, does this case really have much to say about that? We can leave aside the question of, is a wealth tax a direct tax requiring apportionment? That is a important but separate question that is not at issue in this case, and could not be at issue in this case. I mean, that is it. So this case will not resolve that question. Should Congress, no matter how this case comes out, should Congress decide later that they want to impose just a straight up wealth tax, it will be a different, question about the meaning of the direct tax clause, not about the 16th Amendment. So that's an important thing to just get out of the way, that like a wealth tax in and of itself is not at issue here. But what about these other types of income taxes that might be implicated, especially like a mark-to-market income tax? Leaving again, maybe aside the point that like we have a long history of mark-to-market income taxes, as I described earlier, there still is a question of whether this would get at that. And there's two main reasons that I think I want to highlight. One is that you can still distinguish between wealth and income, right? So income, it does without a realization rule. I mean, they're saying you need something like a realization rule, or else Congress can call anything income that they want. And well, no, you don't, because we still can fall back on that, just that there's a difference between basis and gain. Like we know how to do that. We know that there's a difference between the initial invested capital and any gain. Even if that gain is still kind of embedded in the value of the property itself, you can observe the difference between the basis, the original amount invested, and the gain. So even in a kind of a mark-to-market system, we know there is a difference between an income tax and a wealth tax. So there's still going to be two different things. So that's one point to just make very clear. But then the other thing to say is that, like, at some level, this isn't even, or doesn't have to be, a case about realization. I mean, in this case, the income was definitely realized by the corporation. So the question is, or a version of the question here is, can that income be attributed to the owners of the corporation? Can we look through the corporation, have a sort, in the way that, again, the first income taxes did, and we still do in some ways, like the existing subpart F rules, for example. Is that, would that nonetheless, is that going to be, is that a way to think about this, and that would create a problem? And I just want to emphasize that that's important, because unlike, say, a mark-to-market tax, that would be a tax on, something that's a function of the fair market value of the property. So, is a change in the fair market value of property income? That, again, is a different question than here, where you have actual cash earnings of a corporation, of a business enterprise. And it's just a question of who can that be attributed to. This isn't about, to use a language that's in some of these cases, this isn't about mere fluctuations in value. This is about actual realized income, and it's just a question of whose is it. So in that sense, it also doesn't necessarily implicate wealth tax issues.
So that is very interesting. It's a little bit of a red herring there, in addition to being the elephant, right? That's very interesting.
I think so.
All right, Ajay, I wanted to give you one last chance if you want to chime in, if there's something you think that we've missed, or if you wanted to add your 2 cents on the wealth tax.
Yeah, I would just add that a lot, when we go back to the history and we look at what past courts and past experts, whether they be lawyers, economists, accounting, I think it's important to keep in mind that most of these folks in the past actually believed in change, that there was no one single meaning, that there was change, that we can call, whether you call it the living constitution or not. Certainly the experts in the progressive era, the economists and lawyers and accountants even thought about income as a changing concept in many ways, that there was no one sense. And so to try to go back now and fixate on this one kind of definition, as Jake's saying, which is really counter to the way people thought about this, again, before kind of originalism and its pernicious effect on the way we think about the past.
Well, thank you both so much, Ajay and Jake. Thank you so much for joining us today. I learned a lot from this panel, and I'm really grateful to you both for taking the time. What I want to do is pass it over to my dear colleague in the Tax Policy Center, Eric Toder. I see you're there. Good. And thank you guys so much once again. And I'll just hand it over to you to talk about we've gone through the legal history, but now let's hear about the economic implications. Let's hear about where the money's going to go.
Okay, thank you. Thank you for the introduction, Vanessa. That was a fascinating panel. Thank you, AJ and John. I'd like to introduce the panelists. Don't see them yet. Now they're coming on. George Callis is Executive Vice President of Public Finance at Arnold Ventures. Before that, he was a Managing Director at Steptoe, and he spent 15 years on Capitol Hill, where he was a Senior Tax Counsel for Ways and Means Committee and then Speaker Paul Ryan, and was involved in TCJA. Kyle Pomerleau is a Senior Fellow at the American Enterprise Institute, studies federal tax policy. He was previously Chief Economist and Vice President of Economic Analysis at the Tax Foundation. And Natasha Sarin is an Associate Professor of Law at Yale Law School, and she previously served as Deputy Assistant Secretary for Economic Policy at the Treasury Department. So looking forward to the panel. I'm going to make a few introductory comments, and I'm going to ask Ivy to put a few slides up. You can just start with slide 1. I just wanted to make a few comments and present a little bit of data. And these comments are mine. That doesn't look like, there it is. Okay. So the first comment is income is, to economists, is an accrual concept, although we tax many transactions in the tax law on a realization basis. That's a matter of policy, but we understand that income it occurs when you get an accretion of wealth. There are two main sources of unrealized income that might be at risk as a result of this Supreme Court decision. I want to distinguish between those. One is what we usually think of capital gains. You run a business and the market decides, for whatever reason, new invention, better production techniques, your expanded markets, that your business is more valuable. It's going to have higher income in the future. And so the economic value of that business goes up. That's in some sense a pure capital gain. But there's another set of source of unrealized income. There's a semantic issue about whether it's unrealized, but in this case, it's being claimed to be unrealized, where basically you have an entity that is between the investor and the asset. So there's a company that earns income on a current basis, but the income is not distributed to its owners, and therefore the owner, as a result, gets a capital gain and an increase in the value of his or her investment. And that really applies to many of these situations, including the transition tax, subpart F, guilty. So a lot of areas where Americans who own controlling shares in foreign corporations, their income of the foreign corporation is taxed on a current basis. There are also the undistributed income of partnerships and S corporations. And then there are other issues like OID bonds, mark-to-market taxation of commodity straddles, where there is a change in the value of an asset, what might be considered a capital gain. And even though capital gains are generally deferred until realization, in this case, where there's easy conversion efforts or easy chances of avoidance, the Congress has stepped in and taxed those transactions on a current basis. You can go to the next slide. These are not really, numbers here are not really revenue estimates. I'm trying to look at what the current annual receipts are under current law from taxing some of the major provisions that tax unrealized income. One thing to note, that number for a transition tax is not the actual money that the transition tax would raise. I tried to put this on kind of a long-term basis, so it's really the foregone interest as a result of the lump sum, because the tax is temporary, the lump sum revenues it will raise over an 8-year period. It's actually not in effect in 2028, but there's a permanent loss of interest costs to the government because of that foregone tax. So when you look at all of these, they add up to over $100 billion, but it's really important to note that these are efforts to look at what the current loss of receipts is. But if you did eliminate these provisions, there would be a lot of change in behavior, and the panelists will discuss this, that might make those losses a lot bigger than these numbers. So there's a lot at stake. The third slide, I think there was some discussion in the previous panel about progressivity. And so I thought this third slide would be useful. Again, we don't know exactly how any loss of revenue would fall out, but these are the sources of income that would not be taxed. And what the slide shows, if you kind of read the numbers, is that the top 1% of taxpayers, who have about 16% of all income, pay about 50% of tax on interest income, about 77% on realized capital gains, about 78% on partnership income, and about 73% of S corp income. So the consequences of not taxing unrealized income, if any of these sources of income, current income, become untaxed, would be very regressive. I'm now going to move to the panel, and you can take the slides down. And I'm going to start with George. George was involved in the enactment of this proposed Section 965 provision on the transition tax, and worked on TCJA. So, George, how did this fit into the whole idea of what you were trying to accomplish in TCJA, and why was that provision important?
Right. Thanks, Eric, and great to be here. First, let me acknowledge the risk in the fact that I'm a lawyer on the economics panel. So please keep that in mind. If I
Actually, there are two of you, so
right, of course. So okay, good. I feel like it's an even fight at least. Yeah. So we often refer to. I mean, people have different names for this, right? And many of them end with tax, the mandatory repatriation tax, the deemed repatriation tax. I think actually one of the more instructive ones is the transition tax. I kind of don't like to call it a tax. I think that plays into the petitioner's hands because it's really a subpart F inclusion under the existing federal income tax. And many of the briefs in support of the petitioners are referring to it as, a wholly new tax and with terms like that. And it's not. It's an income inclusion. But with that said, I was on the Hill at the time we started talking about this idea as early as 2010. And of course, it became law in December of 2017. And a lot of people say, oh, it was just they needed revenue. Well, the revenue score was nice to help pay for tax reform. But the reality was there was a real critical policy reason for Section 965. And that was to transition from, these are imprecise terms, right? This system of worldwide with deferral that we had, that people had very serious concerns about, that were leading to trapped earnings and lots of pressures for inversions and things like that, to what originally was conceived of as a territorial system, although some might, acknowledge that the GILTI probably captures a lot more earnings than the actual dividends received deduction does, because most earnings overseas are actually supernormal returns and not normal returns. But originally it was to transition to this, we'll call it a hybrid exemption for normal returns and immediate but partial taxation of supernormal returns to get rid of the deferral aspect and the perverse incentives that deferral had. And so, of course, the issue is, well, we want to have this new system for future foreign earnings. What do we do about the existing foreign earnings that are still overseas with suspended foreign tax credits for the technical people, the 902 credits associated with them? What do we do with those? And so I think there were really sort of three options. You could give taxpayers a free pass, which would be a huge windfall. They earned these earnings under a system where they understood they would have to pay some residual tax at some point in the future. And so a free pass would be a windfall. You could simply keep running the old system alongside the new system and have people or have taxpayers have to track two pools of earnings, pre-effective date earnings and post-effective date earnings. Then, of course, the question is, which pool are future repatriations coming out of, et cetera. And that would defeat the purpose of transitioning to the new system, because you would still have this lockout effect for trillions of dollars of accumulated earnings. And then, of course, the third option, which is the one that Congress went with, was, no, we're not going to give you a free pass. But at the same time, we know that not all of these earnings are going to come back anytime soon. Some of them genuinely are permanently reinvested. Much of it is not. And so we don't want a windfall for taxpayers, but we also don't want a windfall for the government. So we're going to tax it all once at a reduced rate, which kind of try to reduce the windfall for either the taxpayer or the government, tax it at a reduced rate. Because it's being done through subpart F, it becomes previously taxed E and P, which means that that going forward, just like future foreign earnings, that can now come back tax-free because it's been taxed under subpart F. And so you don't have differential treatment of repatriation of old and new earnings. And then we can kind of wipe the slate clean and move on with this new system. So that's the context in which it was enacted, and the revenue raised by it was the consequence of not wanting to give a windfall to taxpayers.
Kyle, you've been working on something on this subject for a while, and I think you've been thinking a lot about what the economic implications are and what kind of behavioral responses. So do you want to comment on some of that?
Sure. Yeah. Thank you, Eric. So, yeah, I think at a high level, it's I think it's important to kind of understand realization-based income taxation and how it relates to how should we think about the government if it were to, or the Supreme Court were to enshrine a realization-based system, and what sort of behavioral effects that could cause, how that could kind of limit the ability of Congress to kind of make law, make tax policy. Top level here, I think it's important to realize that realization-based income taxation is not necessarily economically coherent. So the timing of taxation is neither consistent with an income tax or a consumption-based tax. So under a pure consumption-based tax, an individual is only taxed when they consume. Under an income tax, an individual is taxed when their ability to consume rises. So that's the traditional accretion of wealth would be added into your taxable income. Now, a realization-based income tax, however, is inconsistent with either. So a realization-based system is obviously not consistent with pure income tax, because if someone holds on to an asset that appreciates and does not sell it, they're not facing taxation, even though their ability to consume has increased. But it's also not consistent with consumption taxation. So an individual is taxed when they sell an asset, whether they buy another asset or if they consume. Because under a consumption-based system, if you were to sell an asset and then buy another asset, you wouldn't be taxed. But if you were to sell an asset and consume, you would be. And even more, an individual can presumably consume even without selling an asset. So people can borrow money and consume even without selling an asset, and not face any tax. So in addition to being coherent, and I think this gets into some of the behavioral stuff, is that a realization-based system creates a lot of perverse incentives that don't exist under an income or a consumption-based tax. So the first, and I think most people are familiar with this one, is called the lock-in effect. And this is that people delay selling an appreciated asset in order to avoid tax. And this is pretty straightforward. The ability to defer taxation by not selling, that reduces the effective tax rate. So the longer you hold on to an asset, the lower the effective tax rate is. So there's an incentive there to hold on longer than you otherwise would. Then the flip side of that is that there's also an incentive to accelerate the realization of losses. So if you have an asset that's declining in value, you would want to sell that asset sooner than you otherwise would in order to receive the deduction. My favorite example of this, or the way to think about it, is you think about your favorite Netflix show that has been canceled and the news stories that come up about that, about it being written off by the company. And the idea here is that, well, companies might be writing off some of these TV shows sooner than they otherwise would in order to get the deduction faster. Under a pure income or a consumption tax, taxpayer would be neutral. That incentive wouldn't be there. Then there are other behavioral implications of a realization-based income tax that are more strategic. For example, loss harvesting. So this is strategically selling an asset in order to use losses that might offset a gain elsewhere. This is just a short list here, but the tax code now has tons of rules to reduce tax avoidance behavior that are the result of a realization-based income tax. And some of these, and they were discussed in the previous panel, might be discussed more. In some of these rules, they deviate from pure realization-based taxation. They tax mark to market in order to address that. And I think a ruling that's in favor of Moore versus the United States may put many of these provisions in the tax code at risk, and may actually increase the ability for tax avoidance in other places that don't currently exist. Eric had a great list of all these provisions, thinking of a couple of them. One of them is taxation of S corporations or partnerships. Currently, those incomes flow through to the taxpayer, whether or not they're distributed. Some sort of ruling that may put that at risk, or at least allow people to sue the government on those provisions, could lead to taxpayers being able to retain earnings in that form. And then also the tax treatment of foreign profits with respect to profit shifting. George talked about the TCJA, GILTI, Subpart F, those provisions are there. They tax profits that aren't necessarily realized in the United States, but they have a policy rationale. The rationale is to prevent companies from aggressively shifting profits or locating profits in low tax jurisdictions. So ultimately, the risk here is that Moore v. United States could allow people to, taxpayers to sue, or could ultimately result in a lot of these provisions going away. And from my perspective, I think it would be better if Congress were in control of these decisions, and that it wasn't the Supreme Court that was telling lawmakers what sort of limits they have in terms of taxation. And I'll stop there.
Okay, Natasha, I'm going to let you have a turn, and I'm particularly interested because I know you worked in the administration. You worked on some of these proposals to tighten the tax law on capital gains, or maybe you didn't work on them, but you were there when you were in the room when they were being discussed, and certainly have been concerned with tax compliance a lot, and have thought a lot about those kinds of issues, and also are thinking of developing the next round of tax reform. So from your perspective, what are the insights you get from this court case?
Well, thanks so much, Eric, and thanks for having me, and for everyone who's listening. I think the challenge here, as Kyle kind of started to discuss, is really like a pretty significant challenge of uncertainty that Moore poses. And Eric, in your presentation, you started to also make this clear. There are just all of these different arenas of the tax code that implicate the taxation of unrealized income. And even that term, and this came up on the last panel, and just to like do lawyer hat for a second before economist one, even that term is like laden with uncertainty. Because to my mind, there are some constitutional questions that the court is going to have to grapple with at some point, I speculate, which came up on the last panel with respect to things like wealth taxes. And we learned a lot, the mark-to-market taxation of capital gains. We learned a lot in the last panel about the evolution of these legal doctrines and how they've changed over time. That's like one set of unrealized income. And then there are parts of the code where income is realized by an entity, but not paid out explicitly, like in the form of dividends. And the first, I think you have a bunch of people who have argued the constitutionality of this or unconstitutionality of that. The second, of which the Moore stake in Kissencraft clearly is that this is income that's realized by an entity that they owned. And so that's a point that the last panel emphasized, but I just feel like it's really important to say again, because we're having and sometimes the journalists some of whom are listening, who are covering this issue, they are using it, and a bunch of the amici are using it as a vehicle to have a debate about the constitutionality of unrealized capital gains or wealth taxes, with more as the vehicle. But it's like a pretty bonkers vehicle when you actually start to think about the facts of this particular case. And I think it's pretty interesting, now back to economist hat, I think it's pretty interesting that you have on this panel itself, like a very diverse set of tax experts, ideologically, who aren't all aligned, but who are all aligned, though maybe this conversation will reveal some divisions among us, but like who are all aligned with the broad view that it would be immensely problematic with respect to tax administration, tax compliance, broader fiscal implications, which you sort of showed us, Eric, in your first set of slides, if the petitioners win this case. And I can come up with lots of ways in which you have a narrow ruling here. For example, there aren't constitutional limits with respect to taxing corporations. Excise taxes are explicitly permissible, and you get 99% of the revenue from this particular provision from corporations. So something like 10% of this revenue, by the way, just so people understand like who we're talking about, is like around $40 billion in a repatriation tax from Apple itself. So I think you can have you can conceive of like narrow rulings, but even those are running really significant risks because of what Kyle described. And Eric, you were asking about tax reform, which is like a big open question as we get to 2025. And I think that hopefully we're going to have an opportunity to think really seriously about revenue raising going forward and how to fund important priorities that we have and how to address large and growing deficits. What I worry about and kind of keeps me up at night, both for the core code as it stands and for reform efforts going forward, is that there's no way for a ruling for the petitioners to be drafted in such a way that resolves all of the uncertainty that this case is going to open up. And the entire edifice, as Kyle was describing, of like subchapters K, so the pass-through treatment of partnerships, and S, like how we tax S corporations who are electing for their profits to be passed through, which people are choosing, by the way, these vehicles in part for their preferential tax treatment that already exists in the code today. Can you imagine like the behavioral responses that will elicit going forward in a world in which we actually potentially draw into question whether or not we can tax these entities at all in the way that the code currently addresses them? And I think what you will see is there's like a ton at stake here. There's a lot of revenue, Eric, you showed us. And so what you're going to see is a lot of litigation going forward if you have any sort of ruling for the petitioners. And I think that runs really big risks. And I think that what we aren't really grappling with as much is what that cloud of uncertainty could do, not just the direct revenue impacts of anything sort of narrow that might come out of the court, but what that cloud of uncertainty will do that draws into question areas of the code that have been settled for decades based on like a shared and correct understanding of what the Constitution allows for here. And that's like, honestly, I will leave you with this, and I'm curious to keep talking with the rest of my panelists, but like, that's like no way to run a rodeo. Like, that's just like truly a pretty insane state of affairs. And I think a really problematic one for not just the direct fiscal consequences, but what the fiscal consequences could look like going forward if the petitioners win this case.
So does anyone want to comment on what anyone else has said? And not, I'll ask some further questions.
I'm happy to agree with most of what I've heard. I mean, I think Natasha was right, by the way, to credit the first panel. I've said there's like three buckets here. There's wealth, then there's appreciation of an asset, and then there's this. And this is neither of the first two, right? This is realized income, and then it becomes, I think John Brooks said this, then it becomes a question of who you can attribute that to. But it's realized income underlying it all, not the change in the value an asset. But I think Natasha actually did a great job of marrying the legal and the economic analysis here, right? Because a lot of the economic consequences come from the potential legal uncertainty or even legal chaos that could result. And I've talked to many people who are sympathetic to the Moors and kind of want the Moors to win, and they tend to poo-poo everything like the petitioner's brief. Oh no, this is going to be very narrow. It's not going to threaten subpart F. It's not going to threaten by the way, they did not mention guilty in the petitioner's brief. They just talked about subpart F, but not, subchapter S, subchapter K, et cetera, et cetera. And my response to that is, oh, really? Is the Supreme Court going to go through the Internal Revenue Code provision by provision in their decision and apply their ruling to each provision? I suspect they're not. I suspect that if they were to rule for the Moors, they would rule for the Moors on this provision, and then everybody would be left to interpret it and apply it to other provisions of the code as they see fit, which is going to lead to litigation and everybody taking different positions. And that could lead, you could have everything from partnership agreements being rewritten to global supply chains being restructured to debt instruments being designed completely different ways when you get into like the OID rules and so forth. And so the potential economic disruption from people interpreting the decision in different ways and there being that uncertainty until it's all litigated out in the courts, I think it's hard to overstate the potential disruption there.
Yeah, I agree with that. My top concern here is the issue of uncertainty and what a ruling that doesn't specify almost everything would mean. I think also some of the amici and just knowing these organizations, they're big in favor of consumption taxation. I think they view income taxation as this growth of the federal government. But from my perspective, this is really not how you get there. Like I described, realization-based income taxation is neither income or consumption-based taxation. So, you're not really going down the right road there. And even if you are someone who supports going all the way to some sort of consumed income tax, pure consumption-based taxation, you really want Congress to figure this out. You don't want, years and years of lawsuits to get us there. That's the type of uncertainty that I think could be an issue for the economy.
So let me push the hypotheticals a little bit further. Supposing that you really can't tax all these sources of unrealized income or quasi unrealized income. Kyle said result might be Congress decides to throw out the income tax entirely and have a consumption tax, but they might do other things short of that. That seems, how would you imagine Congress or presidents or anybody reacting to that kind of affair? We've had other, kind of issues of second best policies, like in '86 when there were all these tax shelters, they put a limit on interest deductions, for example.
One outcome, well, I don't actually think it would be the outcome, is that Congress would go to a coherent consumption-based tax. I don't actually think that's the case. I think instead you'd get something much more incoherent, and you could get rid of a lot of these provisions, and perhaps how Congress reacts is they would raise rates. So you'd have this base that is really ugly, but also with higher rates, and that would exacerbate a lot of the distortions that we've been talking about.
And I don't even know, Eric, let's take the very extreme world in which you somehow have some ruling that eliminates, this is not going to happen, so I just want to be explicit, but we're doing hypotheticals that are extreme, but that you eliminate the capacity to tax pass-throughs at the individual level in the way that the code is built, right? What is going to happen immediately is it's not like we're going to be able to rebuild, Congress is going to pass them and rebuild the universe instantaneously. So what's going to happen immediately is you lose a ton of revenue because you can no longer tax a whole subset of business income. And you incentivize more people. Everyone will want to be structured in such a way that they might not have to pay taxes. So they're going to very quickly find ways to structure themselves in order to be in this like other bucket. And that's going to be worse in Kyle's world when everyone's raising tax rates to try to protect some tax revenue from the base that sort of we feel secure exists. So it's like I am more convinced that the speed at which the universe will operate is the speed at which businesses are going to be able to find ways to avoid tax liability, which they are pretty good at. And Congress is just going to be like trying to grapple with like, what if the code remains and how do we start over in some sense, given deep incoherence coming out of a ruling for the petitioners in this case.
And George, what do you? I guess you had mentioned when we talked about something about severability. Would this put at risk any of the other provisions in international provisions in TCJA directly or indirectly? And how would you sort of fix this if you had to fix it?
I'm not sure what you're asking me when you say how would you fix it. I
maybe it's not fixable, but.
Well, I think there's serious severability questions. Now, some folks have already written amicus briefs on severability. I have not been as focused on that issue as I have on others. However, having been involved in the creation, I would say outside of whatever the constitutional doctrines are in severability, I don't think we would have done 245 Cap A without 965. I mean, we viewed 965 as how you transition to the dividends received deduction. And as I said earlier, there was not enough support in Congress for just giving company or taxpayers a free pass. I don't know that a sort of two parallel systems could have existed in perpetuity where the old earnings are treated under the old rules. So I don't know that we could have gotten the DRD done without 965. I think that's an open question. And I think that the thinking at the time was that one is the toll charge to get to the highway being the DRD, and that they go together and that they're sort of inextricably linked, regardless of what constitutional severability doctrines are. They're from a policy perspective, they're inextricably linked. Then there's the question of, well, what about guilty? If we hadn't done those two things, would we have done guilty? So, and then there's kind of a domino effect, right? If you didn't do guilty, you probably wouldn't have. Guilty and fitty went together as well. So, and the only reason we did or I won't say the only, the main reason we enacted the beat was because we were doing things that were raising taxes on U.S. headquartered multinationals, and there was political pressure to do something about earnings stripping that also by foreign multinationals, not just U.S. multinationals. So that you could really kind of go through and see none of these things were one-off policies that Congress would have done in isolation. They were all part of an integrated international tax reform. Even to some extent, the corporate rate cut, you might argue. So I think the severability question about where you would cut it off, I think is a very hard question to answer and open for quite a bit of debate and discussion.
Eric, just like one more thing to flag, like directly with respect to severability, and this is Dan Hemmel has written about this. I'm sure others have as well. But without the revenue from the repatriation tax, which was about $340 billion, the Tax Cuts and Jobs Act wouldn't have met the budget reconciliation instructions. Like they needed that revenue. I know to George, there are other policy reasons, but like they needed that revenue. And it would be like a pretty weird, especially given like who is behind the Moors, like a pretty strange outcome if like what happens is you somehow find yourself like taking down the entire TCJ, all of what George just described, in pursuit of a victory for the Moors. They can't possibly want that, right? But that is an extension, a natural extension of what the case might lead to.
I think that's right on. I mean, the 965 was one of the first provisions in tax reform because it was part of the 2011 Chairman Dave Camp International Tax Discussion Draft. So it was originally conceived of, which didn't even have a score, by the way, originally conceived of as an integral part of international tax reform. But as Natasha said, TCJA would not have come close to meeting the reconciliation instruction and therefore would have fallen. That would have been fatal to the bill, to the entire bill, but for the revenue from 965. And I will add that even though 965 was one of the first provisions, 6 years earlier to be part of tax reform, the House TCJA had rates, 965 rates of 14% on cash and 7% on illiquid assets. The enacted version was 15.5 and 8. They were dialed up a little bit at the very end because there were some things that Congress needed to do to get some votes that cost some money that would have taken us over the reconciliation limit. And Congress just dialed 965 a little more to get the revenue to meet the reconciliation instruction. So I say that because I think it reinforces the point Natasha's making.
All right. Well, here's a question from the audience. The panelists seem to be generally aligned on the basis of history, law, and economics. So it would be extremely problematic if the Supreme Court were to rule in favor of Moors. So why do you think they decided to hear the case?
I'll go ahead and say
maybe that's outside the brief of this panel, but
we're all speculating, right? Because
right.
Granting cert, the court doesn't actually say why.
Right.
I do think the Ninth Circuit, in ruling against the Moors, made much broader and far-reaching statements about the lack of a realization requirement than it needed to, whereas it could have ruled narrowly against the Moors on, as many of us have said, because it's realized income actually, and so you don't even have to necessarily get to the question of a realization requirement. I suspect the Ninth Circuit went so broad that they raised some eyebrows on the Supreme Court, but that is largely speculation.
So we're getting close to out of time, but let me just ask one further question. Can you imagine ways this decision might be limited or framed so it wouldn't have the kind of dire impacts that we've been talking about?
If they rule,
well, obviously they could say no, but are there any sort of intermediate positions that are?
You mean like rule for the Moors, but not cause chaos?
Yeah.
My theory of the case, and I will say, I think this is very circuitous, but it's my best effort to try to comply with that intellectual exercise, is that a realization requirement in the 16th Amendment does not apply to C corporations, because the corporate income tax is already constitutional as an excise tax, and you can tax corporations on an accrual basis, yada, yada. It only applies to individuals, this requirement in the 16th Amendment. That only represents about 1% of the 965 revenue. But if individuals are exempt from subpart F and guilty, you still have major problems with the transfer of foreign assets out of C corporations to individuals and so forth. So I think you need more than that. And then you probably need something like a temporal requirement, and it can't be really retroactive, right? Like it's got to be like individuals only and going back 30 years. But I think that's really creative on my part. I don't think that actually necessarily is a great way to get there. I can't even begin to think of any other way.
Okay, well, thank you. I guess it's time to wrap up. So thank you all. This has been a very useful panel, I think, and hopefully the chaos that we fear won't happen. And I'm going to turn this over to Chai-Ching. So take it away.
Thanks so much, Eric. And thanks everyone for the terrific panel. So for this panel, I'm delighted to be joined by Deborah Paul, partner at Watchtower, Lipton, Rosen and Katz, Steve Rosenthal, senior fellow at TPC, and Eric Solomon, partner at Evans, Phillips and Baker. You have their full bios in the chat, so let's just get right to exploring some of the very many ways that tax law, practice, and administration could be affected by this case, and some of the uncertainties that it raises. And I know that we've already had a bit of a taste of that from previous panels, so I'm really excited to hear these additional perspectives on some of these questions. So let me start by asking you, Debbie, what do you think would be the impact if the court held for the wars? And let's start by, let's say that they were to do so by adopting the specific approach to a realization requirement that they've put forward.
Okay, thank you so much for having me. And I should mention the past panels are a tough act to follow. And I also just want to say I'm speaking for myself. I'm not speaking for any institution on this panel. So the short answer to your question is I would concur with the statements on the previous panel by George and Natasha about uncertainty and the likelihood of litigation as people try to understand what the scope of the ruling actually is. So now, just to sort of come at it maybe a little bit differently from how they did, your question is, if the Supreme Court adopts the theory of the plaintiffs, what's the consequence? So that presupposes that we understand what the theory of the plaintiffs is. And that's difficult because I think that they want to have it both ways in their argumentation. On the one hand, they spend a lot of time in their brief arguing that the 16th Amendment requires a realization requirement. And they also rely on McComber for the proposition, as they see it, that you can't tax a shareholder on the undistributed earnings of a corporation. And from that, they say the Section 965, the mandatory repatriation tax, transition tax, whatever you want to call it, is unconstitutional. But they make a huge concession in their brief. They pivot at a certain point to saying, well, of course, there's a concept that they call constructive realization. The idea that you can be viewed as realizing income if you kind of have your hands almost on it, if it's sort of there for the taking by the taxpayer. And they say subpart F is constitutional by virtue of this theory of constructive realization. To me, that's a huge concession. And is in tension with their argument that Section 965 is unconstitutional. As George pointed out, 965 is an income inclusion under the subpart F mechanics. So they don't clearly explain why subpart F should be okay and Section 965 should not be okay. They allude to a few arguments. They don't really rigorously handle this issue. And I think, first of all, the reason for that is probably that it's a bit result-oriented, that they probably care a lot more about trying to elicit some language from the Supreme Court that forestalls a national wealth tax. And, you know, as was also mentioned on one of the prior panels, they're not below the surface about this. Their petition for cert says to the court, you should take this case in order to head off more legislation that hasn't been enacted yet, but more legislation by Congress that may contravene the 16th Amendment. So I think that they styled their brief in a way that is intended to try to reassure the justices that the uncertainty, the years of litigation that Natasha and George first talked about, that won't happen. They're trying to reassure the justices that won't happen, but they don't do a very convincing job of that. They don't explain very carefully why subpart F should be okay. Again, they have a few different arguments, but which we can get into if you'd like. But so I think that's a big piece of it. The other thing that they don't really come to grips with is their reliance on McComber, which of course involved a domestic corporation which was subject to U.S. tax, as compared with Section 965, which involves a foreign corporation that does not pay U.S. tax on its earnings, other than, kind of, if it had any, which it didn't in this case, U.S. source or effectively connected income. So that's a big distinction and question as to why McComber, which did not have a foreign corporation in front of it, why that holding should have a bearing on this case. And they also never come to grips with a point that was raised by, I think, a couple of people, Natasha and others, in prior panels, which is that this is income that is realized. They spend a lot of time about how important the realization requirement is. And this income was realized, albeit by a different entity, the corporation, rather than the shareholders. So it's not, so the short answer to your question is it's not really clear what their theory is, what the Supreme Court, how exactly the Supreme Court would encompass it. But, on the surface, it's subpart F is okay, 965 isn't okay. I think even still, even if you take it sort of at the treetop level, I think there would be a lot of questions, a lot of people throwing their hat in saying, well, I think my provision isn't constitutional either. But of course, it depends on exactly what the Supreme Court says.
Thank you. And just to Eric, I'm curious whether you see a way through this thicket in a way that leads to less uncertainty about either what the Moore's argument actually is. Can it be crystallized in a way that avoids uncertainty? Or is there any version of a victory, do you think, for the Moores that sort of cabins the impact in a way that is fairly clear?
Yeah, well, litigation is a very crude way in order to formulate policy, consistent and uniform policy. And I think Debbie said it well. No matter which way the court goes, for the government or for the taxpayer, and particularly depending if the court does go in favor of the Moores, what the reasoning is going to be extremely important for understanding what the collateral consequences are going to be. So that's the first point. There's the risk of a lot of instability. The second point is, what is the theory? I think the theory is focused on that the tax is really a tax on property, because it's a tax on accumulated earnings, and therefore they're transmuted from profits to property. And so it's a tax on property because the tax is accumulated earnings without a distribution and without the power to compel a distribution. And so to me, that's what I think the theory is. And in part, I think the taxpayer themselves are trying to, in some ways, limit what their argument is and the breadth of their argument. And they are saying, I think, implicitly in their brief, that the other code provisions are not going to be in jeopardy. And I think they concede that subpart F, as Debbie points out, and subchapter K, they also concede is not unconstitutional. So they're trying to tell the court, no, this will not have all these unintended consequences if you rule for the Moores. And I think what the taxpayer is trying to do is really focus on retroactivity. I think that is the key fact, that they are trying to separate themselves from other things like subpart F or partnership taxation, that it's really all about the retroactive aspect of 965. And the question is, okay, if that's where they're going and how they're trying to convince the court that the opinion is going to be limited in its consequences, the question is whether or not the Supreme Court will find the focus on retroactivity to be convincing. If the Supreme Court were to say, oh no, this is really about a retroactive tax on earnings, well, that might potentially limit the possible collateral consequences. But again, every case stands on its own, and it all depends what the court is going to say, just like Debbie said. And what would be interesting about that is, to me, that is going to be a fine line to draw, because apparently it's constitutional to tax earnings currently. It's constitutional to tax them when you dispose of the asset. But I think what the argument is that it's not constitutional to tax the earnings in between. And so I think that's the direction that the taxpayer is going in. But the question is whether or not that is too fine a line to draw, and whether or not the Supreme Court will adopt that, or some other reasoning. And even if the Supreme Court does adopt that approach, how do they do it? How do they what's the reasoning going to be, and what implications does it have?
And also whether it's a 16th Amendment versus due process issue, and only the 16th Amendment was the question on which cert was granted, not due process.
Or really an underlying direct tax issue. I think Jake Brooks on the earlier panel sort of tried to cabin the petitioner's arguments into three things, and his sort of third broad category was sort of really is this stuff sort of actually about wealth. And I think the sort of retroactivity argument, as Eric, you were sort of, it's not exactly clear what that retroactivity argument is, but it does have flavors of this wealth argument, this argument that you were mentioning about due process, Debbie, and then this question of sort of like what's in between. But Steve, I wanted to make sure that we brought you in here, because I think, you sort of thought and actually written with Professor Aviona in quite some detail about some of the provisions of the current code that you thought would be implicated potentially by the petitioner's argument. And I think we've heard a lot of the different sections mentioned already here today, both in your colleague Eric's analysis and in other panels. But did you want to sort of add anything in terms of the scope of the different sorts of provisions that you were seeing potentially at risk under an adoption of, let's say the court were to rule one-line ruling, we agree with the petitioners? What would that actually mean for the code?
So I agreed with the comments from the earlier panelists on some of the tax provisions that could be implicated. I think the big ones fall in three buckets. Our international tax rules, which often require current accrual on earnings of foreign entities, largely passive earnings, the foreign personal holding company rules from 1937, the subpart F rules, passive investment income from the Kennedy administration, 1962. And then you have a bucket of capital tax rules, many of which I helped draft. You saw the first of these with our zero coupon bond rules enacted in 1969, where a taxpayer that holds a bond has to accrue income just from holding the security, the very thing that the Moores are complaining about. And then, and of course, there's other capital markets rules. The ones I helped draft were things like Code Section 475, the mark-to-market method of accounting for securities dealers, the constructive sale rules. Interestingly, when I was on the Hill for the early to mid 90s, we took comfort that we were going along the right path. In 1991, cottage savings was decided, which reaffirmed the language from Horst that the realization principle was administrative, not constitutional. In 1993, shortly before Congress passed and President Clinton signed the mark-to-market for securities dealers, the Ninth Circuit ruled that mark-to-market for commodities futures in 1256 was appropriate, could withstand challenges. And so from my perspective, there's a whole bunch of rules that could be implicated. The other bucket is, of course, pass-through. I'm not as concerned about subchapter S, which requires elections both by the corporation and by all of the shareholders. But I am concerned about subchapter K and partnership on account of, from the start, the turn of the 20th century, partners are viewed as alter egos of partnerships. And so you could tax them currently on the partnership's holdings. But I'm concerned about that today because in the 100 years since those principles were articulated in McComber and earlier, we have LLCs, we have LLPs, we have a change to the Uniform Partnership Act that makes clear that partnerships for local law purposes should be viewed as entities, not as aggregates, not as alter egos. And so, yes, I'm concerned. But let me just step back and make one larger point. I think that the problem here, I don't think this is a due process case, at least yet. That wasn't what any of the cert petitions asked for. That was before the Ninth Circuit, but that was not in the cert petition, that was not in the amicus, that was not the question presented. I think, of course, the court could do whatever it likes, but it sort of let fall back the due process. But the problem with focusing on the realization principle in my mind is that there's some very bad language in McComber that you can't pay tax until you receive something of value. Now, of course, that sort of was whittled back over the next century and honored only in the breach. But nonetheless, if we can pull out language that this Supreme Court could use, and the Moores are trying really hard, and some of their amicus are trying really hard to say, don't worry, court, the bad things that Steve and others think can happen, well, you could distinguish on the following kinds of grounds. But as Debbie pointed out and Eric points out, litigation is an awful way to make rules. It was hard enough in working for Congress to make rules, let alone 9 justices and clerks right out of law school, or maybe one clerkship making tax rules. And so, and all the exceptions, if you read the Moore's brief, and a very well-written but incorrect view was by an amicus by the name of Mark Berg, who does a more complete analysis of how to distinguish all the different tax rules I just clicked off, and there are many, many more, some of which he did not address, and because he's argued that those are unconstitutional. But I'll just finish with this thought. The reason they're doing that is they understand the precarious position they've put the court in. And the question, I think, before the court will be, what does it want to do? Is the court inclined just to say, we interpret the Constitution when Congress writes bad rules? Well, that's on Congress. Or to what extent will the court respect the century of legislating and the decades and decades of these tax regimes, which by and large have been accepted by practitioners and by taxpayers with few complaints?
Thanks, Steve. Eric, I saw you come off mute. Were you trying to add something to Steve's comments there before we?
Nope.
you wrapped it up with a bow. So,
let's keep on going.
You started to sort of bring in this question, Steve, about in the situation of this sort of uncertainty about what the court might rule, and even when it does rule, what that would actually mean over time. Other players in the system having to think about how to react. And just to sort of start with one set of the system, Debbie, Eric, you've obviously been following this particularly closely, but I'm assuming that that's true of other practitioners that you interact with. Is that the case? And are you already starting to see current changes to sort of transactions or practice, or is everyone in the mode of like bracing themselves really right now?
Well, certainly people are talking about it. And I think from the time the court granted cert, people became very focused on it. So there's a lot of discussion within the tax bar about what it all means along the lines of, what we're talking about today. In the scheme of things, we probably will get an answer before too long. I mean, presumably they'll issue their opinion, this term. So I think people are mostly watching and waiting and trying to figure out what the implications are going to be.
Yeah, I would just add to what Debbie's saying. in the transactional space, Debbie can comment on this. Are you seeing anything in the transactional space where people are worrying about this?
Not really, not really at this point. I think it's a little too soon to start saying, wow, subpart F, guilty, all these other provisions are gone. I don't think anybody's counting on that.
Yeah, I agree with you, Debbie. I agree with you in the transactional space. I'm not seeing that, but I must say, taxpayers are wondering whether or not things now are constitutional, and they're starting to think about these issues. Now, going to litigation is always the last resort, because it is, long after whatever happened has happened, and you're spending lots of money on litigation, which is, you never know what's going to happen. But taxpayers are starting to say, hey, is this constitutional? And we see it in other areas. I think there are some arguments being made in some completely unrelated cases, whether the Eighth Amendment excessive fines clause applies to excise taxes. And so we're starting to see taxpayers becoming more conscious of this. And outside this area, in the regulatory area, the executive branch area, not the legislative side, but in the administrative side, the executive branch area on regulations, this is a big issue. Taxpayers are saying to themselves, okay, there's a regulation out there. Did it satisfy all the necessary requirements to be a valid regulation? And so again, even though litigation is something you never really want to do because you can lose and you spend a lot of money on it, I think these issues, these broader issues of validity are coming up elsewhere.
It also occurs to me that wherever we land, the litigation that might sort of kick off with a decision might be particularly difficult to sort of even guess the general direction of, because a lot of the provisions that we've mentioned, some of them are anti-abuse provisions, some of them are taxpayer favorable provisions. Things don't sort of neatly settle in one direction or another. So it's going to be, I think, quite difficult to see the long scope of how that might play out over the years or maybe decades of litigation. But we'll pick back up on this administrative question, Eric, but I'd love to sort of go back to Steve and kind of do a little bit of thinking about, could Congress try to fix this, any sort of uncertainty that they're left with after a decision on, in favor of the Moors? We heard in a different panel that Kyle Pomelo was worried about raising rates and dealing with an incoherent tax base, but is there a possibility of sort of cleaning things up in a way that is consistent with some kind of realization requirement that makes sense? And what do you think are the chances of that kind of response?
Well, let me start with sort of the good news, which was many of the tax rules that I ticked off were developed both by Republicans and Democrats. And the consensus in Congress to view the realization principle as administrative, not constitutional, and for Congress to write tax rules that made sense from a policy standpoint, both parties embraced. You could see from our panels, the prior panel had a Republican staffer, George, defending the Section 965 transition tax. And the work that I had done in the 90s on mark-to-market, introduced by President Bush, signed into law by President Clinton. And over and over again, there was bipartisan consensus. That's the good news. The bad news is those days are gone. And I would be wary of looking to this Congress to respond in an expeditious fashion. I think there's far too much polarization, and in a circumstance of uncertainty, both legal uncertainty as well as how Congress could yet respond, there could be some major consequences. And this Congress has been less equipped to deal with those. And so where I started earlier by describing these broad categories of tax rules to which the realization principle, if it were required and made more stringent, could blow up our international tax regimes, our capital markets tax regimes, our pass-through tax regimes. Yes, those are major changes to our code, but no, I don't think this Congress is up to the task. And so it'd be quite a problem.
So I think we've already sort of discussed a number of layers of potential risk and uncertainty here, but Eric, I might sort of venture your way and add yet another. I think one of the things that you had been thinking about is to what extent this case actually sits in a broader context of challenges to tax laws, taxing power on the basis of administrative law and constitutional law considerations. And just wanted to hear your sort of thoughts about how to locate what's happening in this case and what might happen in that context.
Yeah, just very briefly, I put this in a larger context, and there have been a number of recent judicial developments that deal with the breadth of authority given to the legislative branch and the executive branch. And we have two Supreme Court cases on this. We have the Moore case with respect to the breadth of authority of the legislative branch and questioning what the Constitution allows Congress to do. And then we have developments, even more common developments on the potential limitations on the executive branch, on rulemaking. And there have been a lot of cases on that. But now we have the Supreme Court about to weigh in on the breadth of authority granted to the executive branch, and in the Loper-Bright Enterprises case. So we have the Supreme Court looking at the extent of authority that was given to the Congress in the Moore case, and we're going to have the Supreme Court looking at the extent of authority given to the executive branch in the Loper-Bright Enterprises case. And as we know, on the administrative side, in the executive branch, traditionally there's been a lot of deference given to the rule writers, the rule makers, Treasury Department, and tax regulations under the so-called Chevron doctrine. And the Chevron doctrine basically says, unless the statute is clear, the reasonable interpretation by the executive branch, by the Treasury Department, IRS about regulations is going to be upheld. Well, there are several members of the Supreme Court think that the courts have abdicated their responsibility in this regard, and it's up to courts to say what the law is. And you can see some of the feelings about that. Justice Gorsuch, in a dissent to a certiorari in Buffington versus McDonough, basically says, wait a minute, we need to reevaluate the Chevron doctrine because the court should decide and not defer so easily to the executive branch. So, Moore doesn't stand on its own. Yes, it stands alone with respect to the legislative branch, but it doesn't stand alone with respect to these larger inquiries into the scope of the power of the sister branches of our system. And we not only see it with the Chevron deference, we see it with the Administrative Procedure Act, the challenges under the Administrative Procedure Act. And, perhaps unrelated, the major questions doctrine in the West Virginia versus EPA case. Now, that may not affect tax at all, but the question is whether or not there really was a delegation to the executive branch, whether it's proper for the executive branch to take on very important issues. So all of this is in a much larger context where our Supreme Court is reevaluating these issues. And so you ask what the response is. Well, the IRS and Treasury are already responding. There are proposed regulations out that say that IRS appeals will not consider constitutional claims. These decisions about regulations, administrative law have already been made, basically, is what the preamble says. And so we in appeals, we're not going to look at these issues about constitutionality. And the same in those proposed regulations goes for arguments that regulations are invalid or notices are invalid. So there already is a reaction. Of course, the amount of litigation is increasing greatly, which will use up resources. In addition, again, on the administrative side, which is not the constitutional side, but on the administrative side, the IRS, the tax shelter notices have all held to be violative of the APA. Well, Treasury and IRS are now putting them in regulations. So my only point is to put this in a larger context of the reevaluation of what the roles are of the legislative branch and the legislative branch and the administrative branch of the government.
And I saw head nodding on the other panels on my screen, but Debbie or Steve, anything you wanted to add on that?
I will just say that, you know, my understanding is a couple of generations ago, a person could be a constitutional lawyer and a tax lawyer. And people didn't really think twice about that. And then over the years, there's been increasing specialization. And so you thought you had to choose. Some of us gravitated towards tax law. Other people gravitated towards constitutional law. And here we have things have come full circle. And those of us who practice in tax are also have to have a knowledge of at least certain aspects of constitutional law and federalism. So.
Yeah, I would just add, this all goes all the way back to constitutional class or constitutional law class, talking about the separation of powers.
Yeah.
And that is the essence of some of the issues that we're discussing.
Yeah.
And to echo the theme that 9 justices, each of whom have, I don't know how many clerks, 3 or 4 clerks, who have a couple of years of experience, that's really tough for that institution to upend our income tax regime. As a joint tax staffer, I can describe the process of having measures often sent up by the executive branch, the president, and Treasury and IRS would come up and brief the joint tax staff. And then we would spend time drafting with the political staffs and some very expert drafters. We would have bills that were released or introduced, and there would be lobbyists who came in. And lobbyists were quite helpful to the process, informing us of unintended consequences. Of course, we would dismiss their complaints of the intended consequences. And then the professional societies, the resources we had to develop tax legislation were really immense and very carefully considered by experts who had decades and decades of experience of putting all the pieces together into an internal revenue code. And I'm very troubled by the fact that the Supreme Court has taken this case, because I don't see an easy navigation to an answer that won't, at the minimum, create a lot of uncertainty and litigation in the near term.
Well, I for one, am delighted to get to face that uncertainty with all of you and try and figure out what it means as the court figures its path forward. It's my job now to close out this terrific event and to thank you very much for adding your perspectives to this day, this afternoon, of sort of thinking through some of these implications of a potentially very big case. I would just remind folks that the Tax Policy Center has asked you to fill in their post-event survey and to send them or us any additional thoughts that you have of events. And again, to thank TPC and my colleagues at the Tax Law Center for bringing us all together to think through this issue. Please watch out for additional information as the briefings and the decisions keep flowing. And it's been a pleasure to think about some of these big tax and constitutional issues all together with you. Afternoon.